We ready to go in just a minute? With the open courts provision. We ready to go in just a minute? This always happens with YouTube. Let me see here. All right, we're now live on YouTube. I'm going to call up cause number 2015L-6403 in the interest of the Luekenga children. I understand there's been an agreement.
That is correct, Your Honor. The parties have executed a letter agreement this morning along with the attorneys of record, and we have e-filed that. I'm not sure the court has quite received it yet, though.
I don't know. I certainly have not. I'd like would Mr. Fleetwood recite the what the agreement is.
Yes, Your Honor, and I'll read directly from our letter agreement if that will suffice for the court.
Sure.
Okay. The parties will be designated as joint managing conservators of the children with rights, responsibilities, and duties specified in section 153.073 and 153.074 of the Texas Family Code to be exercised independently unless otherwise provided herein. Jolisa Luekenga shall have the exclusive right to make any and all decisions regarding enrollment and participation in extracurricular activities for both children. The children's primary residence will be designated within and restricted to Belleville Independent School District, but this in no way restricts Jolisa Luekenga from residing in Washington County, nor interferes or restricts with the children's right to choose whom they reside with at any given time. Possession and access, both children will have the same right, and that is to decide which parent to live with. There will be no set possession schedule that requires either child to reside with one parent over the other. The children have that sole right and ability to choose which residence they reside at any given time. Child support, Jason Luekenga shall pay to Jolisa Luekenga monthly child support in the amount of $1,200, continuing as provided for in the agreed final decree of divorce, a step down to $500 per month upon the graduation, emancipation, or otherwise aging out of Olivia Luekenga. This provision in no way prohibits either party from seeking a modification of the terms and amounts of child support as provided for by the Texas Family Code. Medical support, Jason Luekenga shall reimburse Jolisa Luekenga for all medical insurance costs associated with the children. Any uninsured medical expenses shall be split 50-50. Dental support, Jason Luekenga shall provide all dental treatment for the children at no cost to Jolisa Luekenga. Extracurricular activities, Jolisa Luekenga shall be responsible for 100% of all extracurricular costs of Olivia Luekenga, and Jason Luekenga shall be responsible for 100% of all of William Dieter Luekenga's extracurricular costs. There is a modification of the dental practice payments currently being received by Jolisa Luekenga from Jason Luekenga. It requires Jason Luekenga to pay Jolisa Luekenga in the amount of $3,375 on the date of the signing of the final order in this modification. Upon receipt of such lump sum payment, Jolisa Luekenga shall forgive and otherwise release Jason Luekenga from any additional amounts owed under the agreed final decree of divorce for a community portion of the dental practice. Your Honor, that's the agreement between the parties.
Well, you're going to need to explain this to me. If a child elects to live with parent A, what is the access to that child of parent B?
That there is no set or, I guess, dictated possession schedule, so it's left solely up to the children to make that decision of when and where they see each parent.
I really can't think of a worse settlement to leave this up to the children. Put the children in the middle of this. Parents and the court should be making this decision and not the kids. And I'm not even sure if the law permits me to approve an agreement that doesn't have access for both parents. I know if it was left to the discretion of the possessory conservator, I couldn't approve that. And now you're telling me if it's left to the discretion of the children, I can?
Judge, I think if it's an agreement by and between the parties, then yes, I would imagine you could approve it, had it done.
Counsel, there is a Supreme Court case directly on point about I can't approve an agreement that says that possession or that access will be at the discretion of the possessory of a managing conservator. So why can I approve agreement that says I can do one that's at the discretion of a child? It's not technically not party to the case.
I understand that, Your Honor, and I'm aware of that particular case. I don't recall the name of it, but it is an agreement by and between the parties, and there is some enforceability issues. I completely understand that. This is something these parties came up with on their own. They know their children better than we do. They're confident in their children's maturity and level to ability to make the correct decisions, that they're both comfortable with this order.
Mr. Elick, do you have 2 cents you want to put in on this? Have you heard my hesitation? Oh, we lost the court. Wait, we've just lost the court reporter for some reason. So we need to, I guess, wait for her to re-log in.
Who did we lose?
Excuse me. Hello? Yeah. What do we need to do to get you back in? All right, thank you. We're off the record. That was the court reporter calling that her computer in there, letting her back in. So she's logging out completely and trying again. So we'll just have to sit quietly. All right. Can you hear us, Karina? All right, we're back on the record. And I think when we were interrupted, I'd asked Mr. Elick if he had anything he wanted to say about the settlement agreement.
Your Honor, I'll offer this in connection with the last thing the court said about this agreement, providing that the children will elect to be decide which parent they want to stay with and live with, and go back and forth, and without any set schedule. That is our agreement. I must say that as a lawyer from Dr. Luekenga, I agonized over this. What is the best solution here? What is the best chance, without rehashing what's going on and what know about the case and the extent of reviewing everything that I did in this case to prepare, and then eventually with Mr. Through Mr. Fleetwood made this agreement. And may I say, in connection with the agreement, Mr. Fleetwood and I, with the parties, my client and his, we've been working on this agreement since we had the hearing with the court about resetting this. So this was not lightly done. It took lots of consideration and a lot of time throughout these days to reach this agreement. And so our position is for Dr. Luekenga, we'd ask the court to approve the agreement about the access of the children. What's happened is the children are at a point, this 14-year-old girl, as in many cases, the court knows that children, when they get to be a certain age, start deciding where they want to be and who they want to be with for whatever reasons may be the background there. Not going into that in this case, but after considering all of this, my client has decided and entered into this agreement that the best thing is to let the children be in the home and stay in the home that they want to be in at the times they want to be in it. As you noticed, we provided a geographical restriction to Bevel Independent School District. I think you may have heard that. I don't know if the court has the paper copy of the agreement yet in front of you. You just listened to the recitation of it. So neither parent is appointed to have the exclusive right to designate primary residency. That is, there's the geographical agreement. That type of agreement, a parental plan, is approved by the family code to do it that way. And so although hope, all of us were hoping that maybe the original plan had worked out more satisfactorily, we're at this point where this parenting plan let the children decide which home to be in and where they want to be. Dr. Luekenga lives in Belleville, Texas. Ms. Luekenga is in Washington County, Brenham, and they're close enough where where it's not a traveling issue too much for these children to be in these homes. So
I understand, counsel, that when kids get to be teenagers, particularly, that the parents often accede to their wishes, and the visitation is much more informal. The problem I've got is there's no enforceable visitation for a parent who is excluded. Here's two things I suggest if you want me to approve this. One is that we appoint a parenting facilitator for these folks. So if there is a problem with one parent being excluded, that they can attempt to work out alternate arrangements with the help of an expert. I've got the name of a parenting facilitator in Brenham that I can appoint if the parties can't agree on one.
Judge, may I inquire who that is?
Erica Farmer.
I would be opposed to that. I have extensive experience with Ms. Farmer and her services, and her costs are exorbitant. We no longer use her in our custody evaluations and have had to go outside of the county because of her costs. I know that costs are a huge issue here with this group, and Ms. Farmer's costs are exceedingly high for services she's provided for us in the past.
In any parenting facilitator appointment, I'd allow the parties to agree to one first. Failing agreement, I'd appoint. But the only name I have right now in your area is Erica Farmer. The second thing that I would suggest is that I am not going to approve this today as a final order. I would approve it as temporary orders with reevaluation within 60 to 90 days to see how it's going and making sure that no parent is being excluded from access to the kids.
Judge, if I may, maybe take a brief break, speak with my client off the record, kind of explain to her what our options are and what your proposal is at this point, and then reconvene here in a second.
You want me to put you all in breakout rooms? Are you in the same building?
We're in the same building, Judge. I'll just put it on mute.
Right. Let's do that. I'll just mute everybody, and I've got 9:15. We'll be back at 9:30.
Yes, sir.
are you? You're staying COVID free? Good for you. Hey. Oh yeah, we're doing well, but isolated for everybody except our grandkids. But other than that, doing well. Hey, if you got a minute, I need to have a family law question to ask you. This is a little bit odd, but I'm kind of in the case of often high conflict. Settlement is the kids are 14-year-old girl and a 12-year-old boy. And kids decide custody and access to the and there is no guaranteed access to the parent. Kids. I understand they can do that as practical, but as a legal matter, it seems to me that any order I approve has to at least have some enforceable access to the other parent, unless they're have a, unless they're not a good parent. There's no evidence of that in this case. So, what do you think? Yeah. 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 I think what I'm going to do is let them try for 60 days. I'm going to approve it maybe as a temporary order, let them try for 60 days, and I'm going to tell them that I'm not going to approve it as a final order and give them 60 days to come up with something better. Yeah. It does. But, I agree. We've got a difficult problem in this case. Dad is about Mormon and a 14-year-old girl. And mom is not, she may have been raised in a Mormon church. Dad doesn't want daughter dating, cheerleading, wearing leggings, all that kind of stuff. Mom does. So that's the genesis of this problem. 100%. And I don't even know if she would visit with that. So I think you just confirmed what I thought, and I'm going to proceed in that way. Yeah, the other 10 years, I was pretty uncommon. All right. Well, I appreciate you being available, and thank you for your input. You too. Bye.
Your Honor, if you can hear me, I think we're all ready. If you
All right. Let's all come back then. All right, you ready, Karina? All right, we're back on the record. You had a chance to confer with your client, Mr. Fleetwood?
I have, Your Honor, and also had opportunity to speak to Mr. Elick, and
Let me tell you what I'm going to do. I talked to some family law judges that know more than I do, and they agreed with my position. I'm going to approve this as a 60-day temporary order and give the parties a chance to work out something enforceable. I'm going to ask the court coordinator to set a hearing for sometime the middle of October. I guess that would be 60 days. And we'll come back for a review hearing on this. I want to talk to the parties at this point. Dr. Luekenga, Mrs. Luekenga, under Texas law, I believe, and I think it's clear, that you have an obligation to make decisions regarding your kids. I understand that you two have had a lot of conflict between you, both before and after your divorce, about the right things to do with the kids. But that conflict alone is not reason enough to abdicate your responsibility. I don't have any indication that either one of you is an improper parent or should be excluded from contact with the kids. So I can't approve an agreement that could have that effect. Obviously, once an enforceable agreement is done, you could do that practically. You could choose to ignore any possession agreement that's come up with, and that's certainly your right, but there has to be something enforceable. I'm going to give the two of you an assignment. Get a piece of paper, please, and a pen. All right. I want each of you to read a book. It's not long, it's not difficult, but you're both educated people. And I think you'll get benefit from this. The name of the book is The Unexpected Legacy of Divorce. Unexpected Legacy of Divorce. It's written by a woman whose last name is Wallerstein, Wallerstin. And I'm ordering that you get that book from your library or from Amazon or wherever your bookseller is as soon as possible. And within the next 2 weeks, you read that book. I'm also ordering that you write a 2-page summary of your reaction to that book and how you think you can change your behavior based upon what you learned from that book. And I want you to give that to your lawyer, and your lawyer will provide it to the other lawyer and to me within 2 weeks from each of you. The Unexpected Legacy of Divorce by Judith Wallerstein.
Okay.
And I continue to believe that a parenting facilitator would be appropriate for these parties, but I'll let you all discuss that in the 60-day interim where you're coming up with an enforceable order. All right. To either of the attorneys, any questions?
no question, Your Honor. I will prepare a temporary order and circulate to Mr. Elick for signatures, and we'll get that to you.
All right. Anything from you, Mr. Elick?
No, Your Honor.
All right. Very well. If there's nothing else, I'm going to disconnect us from YouTube.